Hi everyone, welcome to part 2 of our general defences tutorials. In this tutorial it is a bit more of a lengthy one, I'm afraid. We're going to be looking at automatism. This is the counterpart to insanity, otherwise known as non-insane automatism. I just wonder if you can think about what the term automatism means. If you look at the word, if you took ism off the end, you're thinking about automatic, acting as an automaton, anything where you don't have control over your actions. And the definition of automatism comes from a leading case in 1963, Bratty against Attorney General for Northern Ireland, and it was Lord Denning that sat on this case. This is what he said: an act which is done by the muscles without any control of the mind, spasm, reflex action or convulsion, or an act done by a person who is not conscious of what he is doing, such as an act done whilst suffering from concussion or sleepwalking. So you see, initially sleepwalking was certainly termed as coming under or being within the automatism defence. But what does this tell us about the state of automatism? This essentially, the examples that are given by Lord Denning here are things that are perhaps temporary or external or caused by external factors. And that's what automatism is about. It's about a person who commits a crime involuntarily as a result of external factors. So potential involuntary actions could include sneezing, an attack by a swarm of bees, or other similar, acting under anaesthetic or a drug or even alcohol, even intoxication, or suffering from psychological trauma, potentially, depending on how long lasting it is. And for that reason, automatism tends to be raised in relation to driving offences, and many of the cases we'll look at have arisen out of those particular offences. Hill and Baxter is a really key case in this area. This involved a defendant who fell asleep at the wheel and hit another car and had no recollection of the incident. So this was a magistrate's case. Many low-level driving offences are summary only, and he was acquitted of dangerous driving. The case did go up to appeal and was heard by Lord Goddard in the Court of Appeal, who upheld the acquittal, and he said a person should not be made liable who through no fault of his own becomes unconscious whilst driving. And he famously gave examples of where automatism would apply, one of them being attacked by a swarm of bees. Now, falling asleep at the wheel is now really seen to be something that is a fault to or by defendants, because there are, of course, updated rules about how long you should be driving before having a rest break, etc., to avoid those type of instances. So what are the requirements of the defence of automatism? So again, as I try to put them into three, the act must have been caused by an involuntary reaction, and this involuntary action must render the defendant to have no retention of control. So they must have a complete loss of control. That's what involuntary means, a complete loss of control. Caused by an external factor, so it must not be due to a disease of the mind. So it's complete opposite to insanity here. We're looking at an external cause. And the defendant must not have induced themselves into that state. They must be blameless. So we're now going to have a look at these requirements in detail. So what do we mean by an involuntary reaction? As I said, it means we must have had complete loss of control. Any retention of control will result in the defence failing. So you've got the case of ISIT from 1978, a driving case. So ISIT was involved in a road accident, after which he drove off in his van so erratically that the police pursued him in a chase through fields. He was charged with dangerous driving and argued after the accident that he had entered a state of automatism as a result of psychiatric damage caused by the road accident. So have a think about whether you believe the first stage of the test was satisfied. Hopefully it'll be no surprise to know that the courts weren't satisfied. He clearly hadn't completely lost control because he was able to drive in his van, erratically, albeit, but he was able to be pursued in a chase. So therefore, that indicates that there was some retention of control there. So the cause must not be due to a disease of the mind. It has to be external. And there's quite a big debate around, as I said, it talked about a bit in part 1 of these tutorials, about the condition of diabetes. So certainly with diabetes, there are instances where you could suffer from an effect of diabetes, but that is or that has been caused by external sources instead of internal. So when we learned about insanity, we looked at the case of Hennessy, where Hennessy was diabetic, and he was suffering from hyperglycemia, which hopefully you remember is high blood sugar levels, usually caused by a failure to take the insulin that you need to regulate your blood sugar levels. This is a natural effect of the diabetes. We can contrast it with the case of Quick, which is a successful case of automatism, where the defendant also suffered from diabetes but suffered hypoglycemia instead. In other words, low blood sugar levels. So just have a look at the facts of that. And this is an example of an external factor deeming to be automatism. And just remember, go back to the effect of these defences. If you're deemed to be insane, then you're almost inevitably going to be given at least a treatment order in the community or hospitalisation. Whereas if you're successful on automatism, you are given a complete acquittal, no treatment, and you are able to walk away. So Quick was a nurse who assaulted a patient. He was diabetic, had taken insulin, but hadn't eaten enough food, and also combined with alcohol did not make for a good cocktail. He couldn't remember the assault because he went into a state of low blood sugar, that hypo state. So this was deemed to be an outside source of too much insulin. So the court actually said that Quick was suffering from automatism rather than insanity. His state was not caused by natural effects of the disease. For example, if he had taken his insulin or too much, as in the case of Hennessy. And what the court said was, a malfunctioning of the mind caused by the effect of some external factor, such as violence, drugs, including alcohol, anaesthetic or hypnosis, cannot be fairly said to be due to a disease of the mind. So Quick was able to gain a full acquittal, whereas Hennessy, who had also suffered from symptoms of diabetes at the time of his crime, was labelled insane, which does actually cause a lot of problems for many academics. And what they're essentially doing is taking the circumstances, deciding whether they are external. So in this instance, you've got drinking of alcohol, and saying, well, these have not caused natural effects of diabetes, even though with Quick, he did suffer from the hypoglycemic state, which is an effect of diabetes itself. So it's, you're right, if you're confused, it is confusing, but the courts are drawing that distinction of the blood sugar levels. So I'll just give you a little summary slide on the position with diabetes. If a defendant has or is suffering from hypo, So low blood sugar, usually caused by taking too much insulin or failing to eat after taking insulin. And of course, in the case of other factors like alcohol, then that will be a finding of automatism. But if a defendant is suffering from hyper, which is high blood sugar caused by a failure to take adequate insulin, then they will be deemed to be insane. And of course, the impact is that one is labelled as insane, the other walks away scot-free. And you might think that this is potentially unfair. I mean, the courts are drawing that distinction between these two types of diabetes, not medical experts, which of course can lead to injustice. So have a look at this before we move on, this previous OCR scenario, and see whether you think or what you think the defendant Rashid would be able to rely on, insanity or automatism. So Rashid suffers from diabetes. He has previously had blackouts and has to take insulin twice a day. He fails to take his insulin for a whole day, and during the evening whilst driving he suffers from a blackout. Rashid loses control of the car, which mounts to pavement and hits Larissa, a pedestrian. Larissa dies immediately. So hopefully you identify that this would probably be a charge of manslaughter. But what defence is he going to be raising here? And which one do you think would be appropriate? And hopefully you've identified that this would more likely be insanity based on failure to take insulin. So he would likely be either detained or given a treatment order. Okay, let's look at other examples. And there are some slides after this that go through these cases in a bit more detail. So you've got the case of Woolley, which is an unreported case. It went to the magistrate's court, but it's one that people do teach and talk about because it was reported in the media so much. This is sneezing. The case of Hardy, who was under the effect of soporific drugs at the time of committing a crime. Soporific means those drugs that are usually calming rather than those drugs taken to increase or elevate your mood and speed. So in this case, Hardy took Valium, which is meant to have the effect of calming, but actually had the opposite effect on him. The case of Crown against T, cases of extreme stress, so that external trauma from an incident, so post-traumatic stress disorder, PTSD. And of course the case of Parks, sleepwalking. But there are cases that we will look at that equally, although later, do appear to be persuaded by this rationale of thought. Okay, so have a read of this case, please, and answer the questions, and we will go through these in class. The case of Woolley. And then you've got the cases of Hardy and RVT. Now, Hardy was successful because the court said that the tablets had the opposite effect. So this was an external factor. RVT, the defendant in this, she was actually unsuccessful. But the reason why it's called a success is because the judge allowed the jury to consider the issue of automatism on the basis that the PTSD was caused by an external factor. The defendant who was raped prior to committing a robbery, and the evidence at the trial was that when she committed the robbery, she was in a trance-like state, so she wasn't really conscious. But of course we go back to the first stage test and say, well, did she still retain some control? If you're able to commit a property offence, you're usually able to retain or have some control over your actions. It's not a reflex action, if you like, or a convulsion, which easily could cause a non-fatal offence against a person or even a fatal offence. Property offences usually require some kind of thought and process and controlled actions. So you can see why the jury convicted her of the robbery, but nevertheless, on appeal, it was held that the judge was right to allow the jury to consider it, which of course is the jury's prerogative whether they agree or not. Sleepwalking, of course, is a really controversial area, so I'd asked you through the insanity tutorial to just have a look at that article about the man who was given the defence of insanity for sexsomnia, so having sex with the victim whilst asleep. But there are other similar reported cases that have been successful with automatism since then, based on sleepwalking. So you've got Bilton, who was acquitted of 3 rapes whilst sleepwalking, and then you've got Eckott, 2 years later, which was involved an RAF serviceman who again was acquitted of having sex with somebody whilst asleep at a party, both of those being successful on automatism. So we do seem to be following the line, certainly that was so clearly put out there by Parks in the Canadian case, of considering sleepwalking and even acts like rape whilst sleepwalking as well. Now, there is, of course, the case of Burgess, the man who assaulted his girlfriend whilst asleep, who was labelled insane. And you've also got another case to compare with called Lowe, which involved a man who beat his father to death, his elderly father, and who ended up with 90 injuries. You can probably find this case online. There'll be some articles about it. Now, the headline was that he was acquitted, but he was deemed to be insane, not guilty by reason of insanity. The judge did recognise that during the murder, by which Lowe had no recollection whatsoever, he was said to have been sleepwalking. He was acting as an automaton. So the judge did actually say that, but the finding was insanity because the judge decided that he needed a hospital order. And that's, you see, the contrast between insanity and automatism. With one, you need treatment, the other, you are deemed not to. So Lowe was subject to a period of time in hospital. I believe he only spent a number of months before he was released. But what these cases, particularly Bilton, Eckott and Lowe, have done is they've kind of raised the profile of sleepwalking as a potential defence in the courts. There is call for sleepwalking to be reformed and to be separate to insanity and automatism. And I just wonder where you sit on whether you think Bilton and Eckott were right to be fully acquitted of rape and not to receive any treatment, or whether you think actually the line of if you commit a serious offence or sleepwalking, you should be labelled as insane because you do need treatment. It's an interesting debate, really. So there is the 5-minute YouTube clip where the expert talks about the case of Kenneth Parks, the Canadian case, which was of murder and attempted murder. We have watched that in class, but do feel free to use this link and watch it again. And what I would like you to do is to write a paragraph of evaluation, if you like, discussing the court's approach to sleepwalking and sexsomnia in particular, and use these cases to do that. And that would be really important as used towards an essay, because sleepwalking is a really controversial area. And what you have on the next slide is a sheet to help you to research these later cases. You've got Lowe, Bilton and Eckott. If you can research these and make sure that you know what the facts are and what the outcome was. Remember, the ratio is the reason for the decision, the ratio bis addendum. Going on to the third part of the test, the defendant must be blameless. So the general rule is that the defence of automatism will not apply to defendants who knowingly place themselves in a state of automatism. It must be blameless. This cannot be self-induced. Of course, if they've put themselves into a state of intoxication, then the defence of intoxication may apply instead, which we will look at in part 3 of these tutorials. But what the court also look at is what the crime is itself. Because even if you've put yourself into a state of automatism, so therefore, on the face of it, prima facie, the defence won't be available. If the offence you've committed is one of specific intent, then you may not be able to form the mens rea anyway. So you may actually end up having a defence to the crime, even though you aren't blameless. So remember, we have this general rule that the defence won't apply to somebody who induces themselves into a state of automatism. But we also have to be mindful of the requirement when committing a crime that you must have been able to form the mens rea. So even if you're not blameless, but you can't form the mens rea, you may still, by law, be entitled to a partial defence. And there are some rules around this. The courts categorise criminal offences into those of specific intent, where there are crimes that the mens rea is specific to that crime, or basic intent crimes, where the mens rea is much wider and can include simply the realising of a risk of committing a crime, the recklessness, if you like. Let's have a look at how we categorise crimes. What I will say is these rules are the same for intoxication. If you decide to become intoxicated, so you're not entirely blameless, which could being blameless could be, for example, your drink is spiked. So let's say you decide to become drunk, then the court have to look at these or use these rules, go on to say, well, what crime have you committed? And could you, despite being not blameless, have formed the mens rea anyway? So the crimes of specific intent mean that intention or specific intent is required. So we've got murder, where there must be intent to kill or cause serious harm. We've got section 18, GBH or wounding, where we have intent to cause that serious harm. We've got theft, where you've got intent to permanently deprive somebody of the property, and dishonesty, and the same with burglary and robbery, of course. And then you've got attempted crimes, the intent to commit that specific crime. So if you've become intoxicated or in an automatic state, and you've put yourself in that state, but you cannot form the mens rea for this one of these specific offences, then you may still have a defence. But if you commit a basic intent crime whilst in this state, then you could, by law, be deemed to be reckless. So you could still be guilty. It really depends on what crime you commit. And the type of crimes that come under this heading, which include recklessness, are manslaughter, section 20, grievous bodily harm or wounding, assault, battery, and of course ABH if that's the level injury. So where do those rules come from? They come from the case of Bailey in 1983. This involved a diabetic who failed to eat enough after taking insulin to control his diabetes, became aggressive and hit somebody over the head with an iron bar. His state was deemed to be self-induced, so he put himself into that state by failing to eat. The Court of Appeal held that self-induced automatism can only be considered where the offence is of specific intent. So he was charged with section 18, grievous bodily harm. If you go back to the table, that is a specific intent crime. So despite putting himself in that state, if as a result of that state he couldn't form the mens rea for section 18, which is the intent to cause that serious harm, he would not be guilty of it. But actually what the courts can do is they can then find you guilty of the alternative basic crime instead and say, well, Bailey can't form the intention to cause serious harm, but he can form the mens rea for the alternative basic crime, which is section 20. So he's at least reckless to causing serious harm. But in actual fact, on the facts here, he was guilty. Not enough evidence to prove he was actually in that state of automatism anyway. That's how rules operate, and I hope that they make sense to you. So have a look at these 3 short scenarios and see whether the defendants here can rely on automatism. So pause please for a minute and complete these. Number 1, hopefully you've concluded that Luke would be unsuccessful. Although he is concussed, which would be an external factor caused by the branch falling from the tree and hitting him on the head, he seems to have still some retention of control. So the test, first stage of the test would fail. For the second scenario, this appears to be similar to the case of Hardy. So Lauren would probably be successful. You wouldn't expect sleeping pills to have the opposite effect of committing criminal damage whilst in that state. So certainly would be successful here. The third one, in terms of the diabetic, would depend on what the blood sugar levels is. If it was high blood sugar, then this would probably not be successful in automatism, but insanity instead. If it was low blood sugar, then this would be automatism. Okay, and the effects of raising automatism is that if you're successful and you are completely blameless, you will be given a complete defence. So you'll have no treatment, no liability whatsoever. You walk away. But if, of course, you're deemed to not be completely blameless and you've induced yourself into that state of automatism, if you're not guilty of the specific crime, you might be guilty of an alternative basic crime instead. So if you're not guilty of murder because you can't form the intention to kill or cause serious harm, for example, you would be guilty of manslaughter instead. So for the rules from Bailey to operate, it may be a partial defence for you instead of a full defence. But of course, if there's no partial defence available, if there's no alternative basic crime available to charge you with, then you might have a full defence regardless. Okay. So what we have over the next adjoining slides are some scenarios. So you've got here 2 scenarios asking you to advise on liability for murder and any defences. Usually this type of question would ask you or require you to consider the specific defences to murder, which are diminished responsibility and loss of control. But here I would like you to consider insanity and automatism. So I will set you a task to complete this scenario at some point. So do please take some time and have a look at it whilst you're watching this tutorial. And what I'd like you to do, if you pause, is just a 2-minute task identifying the main differences between the 2 defences. Then what we're going to do for the final part of this tutorial, I'm just going to take you through some of the evaluation points of these defences. As you can imagine, these defences do give rise to a lot of criticism. It's a really popular examinable area because there's a lot to say. And actually, for a 25-mark essay for OCR or AQA, you really would have to be quite concise in what you're saying. You wouldn't be able to cover all of it. So my advice, as always, would be to pick 4 or at least 4 points to discuss. Make sure you discuss those 4 points in detail. And of course, remember that an examiner might just ask you about insanity or automatism. So for that reason, I'm going to cover them separately. So the evaluation of insanity. This takes me back to what I've spoken to you in class about. If you raise a defence, the burden of proof almost shifts, or if you like, duplicates from the prosecution to the defendant to bring evidence to show that they were acting in that particular way. So if you're raising insanity, or whoever's raising insanity, or indeed if you're raising automatism, you have to bring evidence to the table to show that you were acting in that way. And critics say that that does undermine the notion of innocent until proven guilty and can affect your right to a fair trial under Article 6 of the European Convention on Human Rights. So just something to note there, and make sure you add Article 6 at the end of that point, please. Of course, insanity relies on legal terminology. So this is a legal definition. The idea of disease of the mind is a legal term rather than a medical one. And certainly the test is outdated. 1843, this is older than the Offences Against the Persons Act, so certainly needs updating and reforming. And the Law Commission have looked at this too. The rules can be deemed to be too broad. So the classification of diabetes, epilepsy, sleepwalking as being a danger to the public is not just potentially borderline offensive, but also inaccurate. But then, in contrast, the rules could be deemed to be too narrow. So if you think about the third part of the test, the defence could rule out those who are medically insane if they understand or they know the nature and quality of their act, or that it is legally wrong, but they may still be unable to stop themselves from committing it. Your typical serial killers, have urges. If you think about Byrne, the sexual psychopath who couldn't resist kidnapping, torturing and killing women, under these rules could potentially not be deemed to be insane, because he would understand what he's doing. He would know it's legally wrong, but he's actually unable to stop himself from committing it, which can cause some problems and injustices. You wouldn't want somebody like Byrne to go to a normal prison. You would want him to go to a secure treatment facility, although, of course, then that argument can extend to the social psychology side of whether you can treat somebody for that type of condition, whether somebody can ever be cured, if you like. What I would say that I haven't put on here is something that's really positive about the defence of insanity, are the relaxing, or if you say the widening of the treatment orders since 1991, and certainly in the DVCA of 2004. You've got the ability of a court now not to just detain somebody in a secure unit, but also to give them treatment orders, which shows more of an emphasis on reform and rehabilitation rather than punishment and protection. So you could say that's a positive thing as well, and make a note of that. The evaluation of automatism, so a couple of points here. So the distinctions between insanity and automatism can be confusing. And of course, the evidential burden rests on the defence to prove that they were in a state of automatism at the time. And you could argue the requirement to have a complete loss of control can be really high threshold test and almost impossible to evidence and to prove. And of course, you've got your distinctions in conditions like diabetes, where a person with high blood sugar levels may be considered insane, in contrast to a person with low blood sugar levels who would be considered to be not insane, which causes a lot of controversy. You've got an inconsistency with dissociative states. So T, who suffered from post-traumatic stress disorder, was unsuccessful in court. You've got Burgess sleepwalking, and of course sleepwalking We have a number of cases where defendants were successful, but then cases where defendants were deemed to be insane, which does seem to be inconsistent. So you've got Burgess, Lowe, Eckott and Milton to all contrast there. And then, of course, Parks, where the Canadian courts were very clear that this was automatism. And, of course, the problem with automatism is that these defendants who are successful don't receive any medical treatment, but they may need it. Somebody like Quick clearly needs some kind of treatment order and help to regulate their diabetes and to be taught how to manage it. But the defence ultimately is restricted because it results in a complete acquittal. If courts can, then they will side with insanity because it's a safer way to deal with a defendant who has a condition, but also a way of protecting the public, which is, of course, always going to be at the forefront of the court's mind. It's one of the main aims of sentencing under Section 142 of the Criminal Justice Act 2003, if you remember. So proposals for reform, of course, for level 4 answers, we're always wanting to give some information in an essay about reform, and this goes nicely at the end when we're concluding that these defences are out of date and need reforming. They're not fit for modern times or purposes. The Law Commission looked at this area most recently in 2013 in a report called Criminal Liability, Insanity and Automatism. So they've suggested a number of things that I've simply summarised here, but you could always go onto the lawcommission.gov.uk website and have a look at this report in more detail. So they've suggested aligning of the medical and legal terms, reviewing the decisions of Quick and Hennessy, although the convictions or the outcome rather for them wouldn't change, but reviewing why the courts made those decisions would help to inform future cases. Reviewing the area of sleepwalking, potentially fully aligning with the Canadian perspective. Changing arbitrary and outdated terminology, removing the labelling and the stigma of somebody being deemed to be insane, because of course that's why defendants will first and foremost raise diminished responsibility now for murder. They'd rather raise that than insanity. Abolish automatism completely and replace it with a newly worded defence triggered by a recognised medical condition. So very similar to the updated wording that we see. So maybe abolish insanity and automatism, put them together for maybe treatment orders. Okay, so final slide here. So for your exam skills, you need to be able to describe these areas of law. Please summarise the tests, use relevant case law, and of course we need to apply law to scenarios for assessment objective 2. You may also be given an evaluation question. These are common. If you look back through the exam papers, you will see that these do crop up quite often. A typical question could be, discover whether the rules governing insanity and or automatism are in a satisfactory condition. It might be whether they are in need of reform, for example, for 25 marks. Okay, I hope you found this useful. Some parts have been quite heavy going, I know, but really interesting defences. And if you have any questions, please do ask me. Thank you very much.